All rise. The Court of Appeals, Division 1 is now in session.
You may be seated, thank you. Good morning. We are here on our case number 1 CACV 170699, Helvetica Servicing, Inc. versus Michael S. Pasquan. Counsel, as you know, each side's allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve time, though, you're in charge of keeping track of it for yourself. The clock on the podium will reflect the total amount you have remaining, including what you might have decided to reserve. We record these proceedings, so we'd be grateful to you if both of you, when you first approach the podium, if you'd give us your name and the name of your client for the recording. We have read a lot about this case. We've studied the briefs, the record, prior history, and we've also discussed the case in our conference. So we're pretty familiar with the facts. With that, you may proceed.
Good morning. Jason Goldstein of Buchalter on behalf of Plaintiff and Appellant Helvetica Servicing, Inc. As this court noted, we've been here before. The result as it related to this particular deficiency judgment issue we've referred to in our briefs as Helvetica number 1. In that case, the Court of Appeal remanded to the trial court for a deficiency judgment on all issues with the sole exception of whether a refinance destroys purchase money protection. And that was at page 502, paragraphs 38 and 39. And it's Helvetica's position and why we're here that the trial court erred by not following that remand order, and as a result, a deficiency judgment was entered. Anti-deficiency statutes are designed to protect a borrower from a deficiency judgment on a loan that is used to either 1, purchase a dwelling, or 2, to construct newly constructed dwelling on vacant land. It does not provide protection for anything else. Helvetica 1 recognized that, and that was on page 502 at paragraph 37.
And so does it have to be, and I hope you understand what I mean, does this have to be absolutely new construction on vacant land, or can you buy a house and raise it and start over again?
I think the intent of the statute was that it would either have to be, on the plain language of the statute, it's only when you're purchasing a dwelling. Based on this court's Helvetica 1 position and comparing it to Prunty, it stated that there was also a basis for it to be considered protected if it was vacant land and purchased on it. I think if the lender knew in advance that the property was going to be completely razed, like down to the dirt, and rebuilt, then that would be up to either the legislature or this court to declare as being purchase money. However, in this case, we don't have that.
So how could, following up on what Judge Howe asked, and maybe it's the same question in a different way, how could the borrowers here have done what they did, ended up with an 11,000 square foot home, and preserved the anti-deficiency protection under 729?
I don't think that they could have in this situation, Your Honor. There was at all time an existing dwelling that they lived in, and throughout the entire scope of this project, they lived in it. It was never demolished. In fact, in Helvetica 1, and one of the reasons that we believe the trial court erred is the trial court conflated the references to Michael Pasquan's declaration, which was submitted in opposition to the summary judgment motion, as being binding on the court, when in fact we were allowed to litigate it on remand And on remand, we established that as it related to a Prunty analysis, the declaration was incorrect. Paragraph 2 of Michael Pasquan's declaration stated that most of the house was demolished. That's simply not true. It was never demolished.
Okay.
It was.
Yeah, and we know that testimony.
Okay.
He said over and over again, we remodeled. That's what he said.
Right.
What if the borrowers here had made 3 loans? 1, to buy the land. 2, to raise the house. 3, to build the 11,000 square foot house. Would loans 1 and 3 be covered by the anti-deficiency statute 729?
If the third loan was made while there was nothing but dirt on the land and the lender knew that was the purpose, yes, it would be.
Okay.
I would say that's not the situation we have here, and that it's not even close.
Right. But that could be how they could get farther down the road in terms of gaining protection for all that money, some of that, a bigger part of that money.
Yes, Your Honor. I think there has to be a distinction between the intent of the statute, which was to protect borrowers who purchased property, from those who decide that their 4,000 square foot luxury home is not luxurious enough and it needs to be an 11,000 square foot one. And in this instance, I think it's a little more egregious in the sense that, in this instance, the borrower took out these loans while living at the property to pay himself to swing a hammer and to hire workers and independent contractors over a period of years and in stages to complete this remodel project, which he testified obviously was a remodel. And I think it's also important to point out that while the anti-deficiency statutes would apply to a newly constructed residence, which is not the situation here, there were also numerous things that were included that the trial court found were protected that had nothing to do with even remodeling a residence. For example, there was a $300,000 cash down payment when Mr. Pasquan purchased the property. That was included as part of being purchase money loan, but it wasn't. That's just a down payment in cash. It only protects the loan. Enclosing a garage, that's not constructing a residence. Preparing a standalone garage, that's not newly constructing a residence. Landscaping, a pool. In fact, in Helvetica 1, they specifically cited the California Allstate opinion that said that the pool wasn't covered. So there's just so many situations in this case where I believe the totality of the evidence at trial, which is undisputed, establishes that this is not a purchase money situation and that it's not even close.
Counsel, I know that this isn't this case, but if the house were not habitable at all, and they would need to build a new house, would that make any difference in the analysis?
If there was an existing structure already on there that we would
that wasn't habitable.
That you couldn't live in while you remodeled it.
I don't think so. I think the distinction goes to vacant land, whether you use the example of the Prunty, where it was vacant land at the very beginning that was already owned, or if the borrower had raised the property down to the dirt and then got a loan. I think those are the situations that we're dealing with, and that's what the anti-deficiency statutes were designed to protect. And I think I said I wanted to reserve 5 minutes. I'm watching the clock, but in case I didn't, I just want to say that, and I am watching. But I think that is where the legal line needs to be drawn. There's obviously the desire to protect borrowers, and when doing so, in the purchase money context, I see that being there, but there was periods of times where borrowers were using refinance loans to take cash out and treating the equity like ATM machines. And at some point, the borrower has to be responsible for its actions. Here, if someone buys a property that already exists and then improves it, I think that's something that should be on the borrower and not on the lender.
Although to be sure, the cases have extended 33-729 a ways off from the text. That being said, though, it seems to me that why the anti-deficiency statute works is that it applies when the borrower borrows money to improve the property. Put differently, the lender can choose to loan only for purposes that will enhance the security of the lender. Under that scenario, why wouldn't it make sense to hold that as long as the borrower does what he tells the lender he's going to do with the money, it's still within the statute?
Well, I think it goes well beyond the text of the statute itself, and I think there has to be some line drawn to where a borrower has to be responsible for its own actions. And so I think that taking it to its logical conclusion, anything a borrower does to the property, so long as the lender knows when they're loaning money for it, means that they can never get a deficiency judgment. And I just think that if that was going to happen, I think the legislature should state that, as opposed to what we have on the books is it deals with purchase money and the less the balance of the sales price. And I think that if we take it one step to, okay, if you make a brand new house on a dirt lot, fine, I can see that being logical and in accord. But when we go to start going to improvements and things like that, I think one that goes against the Arizona Supreme Court opinion of Ludi, Southwest v. Ludi, which says a home improvement loan is not covered. Property improvement loan.
What does that mean?
Well, I would say you have an existing property and you improve upon it. Here they had a 4,000 square foot home and turned it into 11,000 square foot. Also did extensive landscaping, purchases appliances, purchased TVs, paid himself. I mean, this, I think, would stretch far beyond the intent of the legislature on what should be considered purchase money.
Are the appliances covered? Something like that?
The appliances were added as part of being purchase money, as were the landscaping, as were the TVs.
So if I'm under what the trial court did, if I decide I can't afford a Sub-Zero right now when I'm rebuilding my kitchen, but I'm going to put it in 2 years later, I can count the Sub-Zero 2 years later?
That's in all intents and purposes, yes, because that was included as purchase money. The only non-purchase money that the trial court found were some debt and credit cards and an unsecured loan from his father.
Yeah.
Other than that, there was no other items that were deemed non-purchase money. And the ones that's kind of scream out at me are the $330,000 down payment that he made on the house. That was not a loan. That was a down payment. You don't just get that back. The standalone garage, the enclosing the garage, the landscaping, obviously the appliances. I mean, there's a litany of things that are clearly not purchase money, and there was no newly constructed residence.
I've got a question about application of the rule and how the math, okay?
Yes.
Assume that after a foreclosure sale, a deficiency remains. The court finds that 1/4 of the secured debt was a purchase money loan under 729, and 3/4 of the debt was not. Okay, so 1/4, 3/4. Would it be appropriate then for the court simply to say the borrower is protected as to 1/4, but is personally liable for the 3/4 of the deficiency?
Yes, I believe so. There's also the fair market value credit and how that would have to be
Well, but
applicated.
Under my scenario, the deficiency, maybe I should have said this, the deficiency is what results after application of the fair market value, right?
Correct.
Okay. So you've got the amount of the default, or the amount owed. You subtract the fair market value. And would it be appropriate then, is what I'm asking, to apply the ratio 1/4, 3/4 to what remains? Am I forgetting something?
Yeah, no, I'm just trying to put it together.
Uh-huh.
I think the court could do that. I would think that the 1/4 could be included already in the fair market value credit. And the question is, does the borrower get a double credit? Because the purchase money there's the fair market value credit, and wouldn't that necessarily include the purchase money portion? Why does that have to be separate? I think that analysis the court gave would be the most beneficial to the borrower, and I think that was our
Option 3.
Option
I think.
3.
3, yeah.
And there is no bright line answer as to what the calculation would be, but our point is it clearly was not $341,000 that the trial court came up with, and we tried to give 4 options that we came up with that were possibilities. We believe the evidence at trial is undisputed, and this court has a record before it to be able to make that determination itself as opposed to remand it if it so desires.
Explain the double counting again. I'm sorry, I'm not getting that.
Okay, so there's the total amount due, the fair market value credit, and then we have the remainder. Why is the purchase money not included in the fair market value credit? Why does that have to be separate? In the scenario you gave, where you already have the fair market value credit, and then you have the deficiency, if the purchase money amount is less than the fair market value credit, why is it not considered to be subsumed within the fair market value credit? It's already not recoverable. Had the purchase money portion been larger than the fair market value credit, maybe it'd be a different analysis. But to kind of perhaps get a double credit is all I'm saying. It's the most favorable to the borrower out of the options. But I think that there is an analysis, and this court's in a unique position with a full record and having been here twice to determine what that is. But it's our position that it's definitely not $341,000. And either of the 4 options we think are preferable. I'm actually right at my 5 minutes. If I can reserve that for rebuttal, I'd appreciate it. And I thank you for your time and questions.
Thank you. Good morning, Your Honors. If it may please the court, my name is Dan Kloberdance. I am counsel for the defendant, Michael Pasquan. And let me work backwards a bit. I want to correct something that I think Mr. Goldstein said. I'm sure innocently said, but it's absolutely mistaken. When Michael Pasquan purchased this property, purchased for I believe it was $935,000 originally. He borrowed $600,000 from Hamilton. The down payment that he paid out of pocket never got included in the purchase money in that calculation. So that was lost money to him. He received a credit for purchase money for the $600,000 he borrowed to purchase the property. He did not get any credit for the additional $300 and some thousand he used as a down payment. I want to clarify that. If you look at conclusions of law from Judge Hanna, number 3 and number 4, you'll see that Judge Hanna provided a $600,000 credit towards purchase money. That's the amount he borrowed. Judge Hanna did not include the down payment that the Pasquans paid to purchase the property originally. Also, I don't know where this is in the record, but there were no televisions or anything of the like that were included in the purchase money calculations. At trial, we had literally 1,900 pages of receipts and invoices that Judge Hanna had to kind of go through, and there were no televisions.
Appliances? What about the kitchen appliances?
There were some fixtures, so if a kitchen appliance was something that was built in, I believe it would be included. Something that was taken out, such as a television or something, those were not included in the calculations.
Okay. So, counsel, what is the rule you'd have us articulate here? How far down must the property be torn down before we should consider it new construction?
Well, I don't know if you know, I can think of some very difficult cases where it'd be a close call. This is not one of them. And you know, home improvement loan versus a construction loan. That's really what all this case is about. We don't know what a home improvement or property loan is. Ludi, as this court recognized in Helvetica 1, in paragraph 25, Ludi doesn't say anything what a property improvement loan is. We don't, new carpet, paint, you can go get a property loan and take the money and go to Vegas.
We know a new pool is not.
Yeah.
We know a new pool is an improvement, and it's not protected.
If you, and here's kind of the irony, and you're right, Your Honor.
Is that right?
I think that's based on California law. There's a case that says a pool, if you add a pool, that's not a construction loan under California law.
Have we not adopted that?
No. But if you buy a new home with a pool in it, That's certainly part of the purchase price.
Well, that's the irony of this, isn't it?
It is. And really, we're pounding our heads over something we don't need to be getting into these semantics. First of all, I want to say the word remodel doesn't appear anywhere in the case law. It's a term of art. Remodel. I looked up the definition of remodel, and it means to alter or change a structure, to remake. I don't know what that means.
Similar to improve?
Yeah, gets you more.
Similar to, it could be improvement, it could be construction.
Can we get back to what would be the rule?
The rule should be, I think the rule should be the court should determine, let's look at the public policy. The public policy, as pronounced by Judge Downey in this very same case 6 years ago, is a construction loan is akin to a purchase money loan. Should be provided for the same protection. If you borrow money to construct a residence, you should have the protection of a purchase money loan.
And that's in the context of there is not a home existing.
Well, not necessarily. I think that's an overreading. Let's go back to what Judge Downey says in her opinion, because I think this is very important. This very issue of the teardown is already been decided by this court in this case.
Let's assume it's not been decided.
Okay. Well, I want to say paragraph 3 of Helvetica 1 decision, which specifically says, and let me read this, Your Honor, and then I'll address your issue. The Desert Hills loan, that's one of the second loan here that was paid off with the Helvetica loan. The Desert Hills loan proceeds paid off the Hamilton loan, that was the acquisition loan, and also funded the demolition of most of the existing residents and the construction of an 11,500 square foot home in its place. So Judge Downey, when she rendered this opinion, the facts before this court already were that this was a teardown of most of the home and a construction of an 11,000 square foot home in its place. Then she determines that construction loans are protected. So this court was well aware of these exact facts.
Did the court in Helvetica 1, if I read Helvetica 1, we enunciated the rule that construction loans would be the same as purchase money loans, but did we say that that all of the construction loans were qualified to purchase money?
Well, what the court kind of what the court instructed was for the trial court to determine, and I'll read you exactly what Judge Downey instructed the court to do, whether and to what extent loan proceeds, beginning with the first Desert Hills loan, were dispersed for construction of the residence and or payment of the remaining purchase price of the property. And so the court's instructing the trial court to determine if the Helvetica loan proceeds were used to refinance loans that were used for the construction of the residence. And that's exactly what Judge Hanna did. I mean, he painstakingly went through this analysis and determined that over $600,000 of this $3.4 million loan were not used for purchase money purposes. So that's what Judge Hanna did.
He did do some parsing of it. Now, what I hear you saying in response to the questions is, well, when you have a situation in which someone borrows money to rebuild, expand, effectively change most of the home, then the rule applies. How are we ever going to apply that rule?
Well, I don't know if the rule is limited to most of the home.
Well, then
but certainly it applies to most of the home.
What rule should we say?
Well, I think
it's our job now to articulate a rule.
I think you look again. You go back to the public policy and you look at whether or not step in the shoes of what what Helvetica Court is directing us to do. That if it's used for purposes of construction of a home, and I think that means something more than paint and carpet.
What does it mean?
No,
Say it.
nobody knows.
Oh, that's
But it
so
certainly
fair.
includes.
We have to say what it
But it
means.
certainly includes an expansion where you can't improve something that doesn't exist. So we've got 7,000 square feet of a home that did not exist.
So if you enlarge the
previously.
home.
If you enlarge a home, certainly that qualifies.
Well, a new room.
And that's all we need to decide today.
No, I'm sorry, it's not. Our job is bigger than that.
Okay.
What if all this had happened over a period of 10 years? What if Mr. Pasquan had borrowed money to add on or to do the master bath in 1 year? 2 years later, he decided he wanted another room. 3 years later, he really needed that detached garage. And 4 years later, he needed the pool.
What?
Would all that, now, so it's done incrementally. Do you look backward over time?
I think you have to, and it's a difficult task.
Have
and
to?
I think to determine whether or not this is a construction loan, let's keep in mind here that the borrower Helvetica made its loan. The home was already completed.
Well, that's right, but it takes the characterization.
It passes through. And if the Pasquans had purchased this home, or if they had sold it to themselves, transferred title to their family trust, and repurchased it from themselves, borrowed this money, 100% of this loan would be protected by the anti-deficiency statutes. 100%. And keep in mind, this loan was made right before the market came crashing down, and that's why there's this deficiency. Nothing to do with the construction of the home. The home praised for $4 or $5 million at one time. But the market came crashing down. Who should bear the burden of the market crashing? Well, this court has said time and time again, in fact, decisions you've authored, that the purpose of the anti-deficiency statute is to protect borrowers who lose their home, as Pasquan did here. The home was foreclosed on. Helvetica got it back at the sheriff's sale, and they shouldn't. The public policy is that borrowers shouldn't lose their other assets if they lose their home and the lender forecloses. That applies to purchase
The public
money.
policy is that the borrower always wins?
Not always. If it's not a purchase money loan, if it's not 2.5 acres,
Right,
if they don't utilize the home as a dwelling, the borrower loses.
Counsel, perhaps this is just a different way of asking the same question that the panel has. At what point does remodeling become construction? I mean, I think for the easy, it's easy to say, putting, slapping the paint on the walls, putting new tile down, building a kitchen island, that's all remodeling. But when so is a dividing line when you add square footage to the house?
I think that is a defining line. It may not be the only defining line, but
How much square footage?
well, I think I mean, if you add, if you enclose a patio, you could argue that that's not necessarily, adding because it already exists. But I think if you add anything to a home that did not exist before, I think you got to call that a construction loan. I mean, it could be a remodel, it could be a home improvement loan and a construction loan. I don't think those terms are mutually exclusive. But here, what this court has already decided is, based on a very thorough analysis from Judge Downey, construction loans are treated as purchase money loans for purposes of Arizona's anti-deficiency statutes. So the question is it a construction loan? I think that's the only question this court should examine, not whether it could be called something else, because those terms are not mutually exclusive, really. They're terms of art. But is this a construction loan? Here we have a $2 million construction project where a 4,000 square foot home was mostly torn down in stages, replaced with an 11,500 square foot residence, a new luxury home, at a cost of over $2 million. Is that a construction loan? If that's not a construction loan, then I don't know what is. It has to be, and this court's already decided.
Were the landscaping costs included in the protection?
There was some landscaping, but Judge Hanna went through all of that.
He went through it. That's right.
Yes.
But now that's on review. And my question to you is, how does landscaping constitute a construction loan?
I don't even know what the landscaping costs were. They're very minimal in this case. There was some plants put in, and again, Judge Hanna found that $600,000 was not included.
I bet they were not minimal. It's a big lot.
It is a big lot. But if you bought a new home and here's the irony you pointed out before, if you
Irony.
bought a new home with landscaping in place and you buy it as a package, it's considered purchase money. It is a construction. If you just did landscaping only, I think there's the footnote in this particular case that maybe that shouldn't be included.
You know, what I'm struggling with is we've got the two statutes. We've got 33814G, which grants protection, anti-deficiency protection after a trustee sale of any debt secured by the requisite characteristics of property.
Correct.
And then you've got this one, 33729, which applies to purchase money. So we need to have there has to be some meaning to purchase money. We have to attribute that. So it's not just any debt secured by a home site.
Well, I agree. And in this case, if Helvetica, the lender, had performed a trustee sale, they wouldn't be allowed
Right.
to pursue a deficiency
Right.
at all.
But that's not what we have here.
That's
So
not what we
what's-
have here.
What's the difference? What do the words purchase money or money for the purchase of, I think is the way the statute reads. What does that add to the analysis?
Well, I think that's already been addressed by this court in Helvetica 1. In fact, I think Judge Downey went through a very, very thorough analysis, twofold. One, determine whether or not a refinance can be a purchase money, in which case this court concluded refinance retains the characteristics of the loans that it refinances. That's really not an issue here today. The other portion is a construction loan. Funds used to construct a residence are those entitled to purchase money. And back in 2012, that was an undecided issue. That there was no case law in the state on whether or not a construction loan would be considered purchase money. Now it's kind of a given. But this was the first case that decided that. And again, you go back to the public policy of kind of the absurdity of we're going to protect someone who buys a home here, but we're not going to protect somebody who borrows money to build a home here, when really those borrowers are deserving, if you believe in the anti-deficiency statutes.
What if, going back to the remodel in stages question, okay? So your client buys the home. A year later, he decides to add on a bathroom. Things go awry. The issue then is whether the $10,000 he borrowed to buy a bathroom is a property improvement loan or a construction loan. What's the answer?
I would say if he added a bathroom to the house, it's a construction loan. If he remodeled, use that term, remodeled or updated the existing bathroom, it's not a construction loan. That's my opinion, and I think that's a fair reading of the case. So
what if he turned? What if he built a wall in an existing huge master suite and converted some of it, an interior wall, into a bathroom? Would that be covered?
I think you'd have to. I don't know, Your Honor. I mean, I'm being real blunt with you. That's one of those gray areas. That's a gray area, but we're not in this gray area. We already have this court saying that a demolition of most of the existing residence and construction of an 11,000-foot home in its place is a construction loan. This court's already recognized that in the Helvetica 1 opinion.
Well,
Yes, Mr. Judge.
I thought you answered just a few minutes ago that adding square footage makes it a construction loan. So if you convert, so now you're saying that if you convert part of a closet to a bathroom, that counts as construction? Are we expanding out the house, No.
Judge? No. I would say it's not. I'd say if you're just throwing on paint and putting in some interior doors and putting in new plumbing fixtures, I don't think that's a construction loan for purposes of the anti-deficiency statutes.
What in the statute tells us that?
Nothing. There's nothing in the statute tells us that. So we're relying entirely on public policy and the words purchase money, and a lot of reliance on California law and just, again, looking at the purpose behind the this is a consumer protection law. And Judge Downey, again, everything you're asking, I think, is answered in her opinion, maybe not without the details of some of these more difficult issues which you're raising, but we don't need to get to that today. And that's one thing I agree with counsel is this case isn't one of those fine lines. I disagree with his outcome, but here we have a massive construction project, and I wouldn't say it's done in stages, because stages implies something's done, it stops, something's done, it stops.
Well, that was
here
my
it was done over a
hypothetical
period of time, a long period of time. Like many construction projects, it didn't stop and start again. It was one long project.
Have you found any California cases after the Allstate or Prudy that tell us anything about how the laws developed in California?
I have not. I have not found anything in addition that wasn't raised in my original briefing in 2012, 2011, I guess, when I filed the brief. So there's not a lot of California law, and we can argue Prunty, to the cows come home what that means. But
Well, that was an easy case.
yes, that was an easier case. But here, I think this court needs to defer to what's already been in the opinion from the same Court of Appeals in the Helvetica one, and that is that a tear down of an existing residence and a construction of a larger residence in its place is a construction loan. That's what the court recognizes these exact same facts in its opinion. And I'd direct you to footnote 6 of Helvetica 1 also, which confirms exactly what I was going to say.
Just to confirm the facts, this is not a complete teardown, right? Because
it wasn't
continued to live or
in various rooms, so it was torn down in pieces. Yeah, it wasn't a complete tear down where it was raised, leveled, the slab was taken out and put in. No, part of it was done over a long period of time. Yes, and I want to just make a question on the proration that Judge Hanna prorated this. I asked that the monies be applied first towards all the purchase, towards the non-purchase money. Judge Hanna rejected that, and he applied a proration evenly to non-purchase and purchase money, which I think is a fair result. That's why I didn't do a cross appeal.
Go ahead.
It looked to me like what Judge Hanna did is that he took the amount owing, subtracted the fair market. No, sorry, he didn't. He seemed to apply the fair market, a ratio of the fair market value to the two components of the debt. Would it make any difference arithmetic-wise if you do what I suggested to your adversary, which is take the amount owing, subtract the fair market value, that's your deficiency, and then hold the borrower liable for the proportion of the overall debt that is purchase money or not purchase money versus the other?
I'm not a mathematic genius by any stretch of imagination, but my belief would be it'd be exactly the same.
I think my son would call it
I think it comes out the same.
transitive property. It doesn't depend on when you multiply, as long as you're multiplying.
Right, and he prorated it equally. Again, contrary to my urging, Judge Hanna applied it equally. So it did. The credit was applied pro rata to non-purchase and purchase money obligations.
Just one last question back to the issue of the rule we should articulate. We had some discussion where your position is that any addition to the home, adding a room, any square footage addition would entitle the borrower to anti-deficiency protection, right? That's your position.
Yes, that's my position, but I want to emphasize that that's not the position I'm advocating for the reasons that the court should affirm the decision, because here we have something that is so much more than just an addition of a bathroom to a home. Here we have 6,000 or 7,000 square feet.
Okay.
A very massive construction project.
So looking back at Helvetica 1, in Helvetica 1, at paragraph 32, we said and I quote, "We hold that a construction loan qualifies as a purchase money obligation if, 1, the deed of trust securing the loan covers the land and the dwelling constructed thereon, and 2, the loan proceeds were in fact used to construct a residence that meets the size and use requirements set forth in ARS 33-729A. In the case at bar, these are questions of fact that must be resolved by the Superior Court on remand." So doesn't your position go well beyond that? I mean, well beyond the construction of a residence that meets the size and use requirements? And wasn't there already in place a residence that met size and use requirements?
There was already, to answer your second half first, yes, there was already a residence in place that would have met the size and requirements, so it'd probably being under 2.5 acres and habitable.
And at all times there was a residence that met the size and use requirements?
I presume so, because the size of the lot never changed, and you always there was a dwelling on the property, which is a requirement to be protected under the anti-deficiency statute anyway. Property needs to be intended for occupation or actually occupied.
So then the construction was all addition to the standing residence.
It was addition, and this is the record before the court before and now. Most of that home was demolished, and then this 11,000 square foot home was put in its place. And this is
but at all times there was a residence in place.
At all time there was a residence,
habitable
residence in place, because somebody was living there, at least in one room at a time. And that's what Judge Hanna found in his findings of fact 13. He followed that instruction and made that determination of tracing back those funds. But there's nothing. Again, there's nothing in the law that says that that you should forfeit your anti-deficiency protections merely because you're able to reside in a portion of the home.
But there's nothing in the law that says that you avail yourself of anti-deficiency protection when you continue to increase the inhabitable home you already have on the property.
To the extent it's not a construction loan, I would agree. To the extent that these are considered construction loans and these are construction costs that refinance, I would respectfully disagree with you that is exactly what's covered under Helvetica 1.
All right. Thank you.
Thank you. Thank you, Your Honor.
Thank you, and I'll be brief. In Helvetica 1, as paragraph 32 pointed out, I believe it's clear that when the term construction loan was used, it was used to construct a new dwelling, not to improve it. And obviously, with any loan that's done to improve something, you could say that there's construction going on. But in order to be protected, it has to be in order to actually construct the dwelling thereon. And the analysis that they gave in Helvetica 1 was particularly to Prunty. And in Prunty, the situation was that there was a vacant lot, that they applied for the loan with there being a vacant lot on there, and the lender agreed to fund the loan to construct the dwelling on it. That appears to me, I'm sorry, Your Honor, I didn't mean to cut you off.
Then, if because it was already a home there, any of the construction costs would not be covered as a purchase of money mortgage, and it would seem odd that if that were the case, why would it be remanded for factual development when under your analysis none of it would be covered? Or am I misunderstanding the situation?
The reason the case was remanded is because Helvetica won at the trial court on a motion for summary judgment where the single issue was a refinance loan destroys purchase money protection. Helvetica 1 disagreed and said it did not. The only other evidence that was presented in opposition was Mr. Pasquan's declaration, which stated the information that was used for the factual background in that decision. However, that factual background is not the law of the case. It did not establish any facts because the Helvetica 1 specifically said we could litigate those facts on remand, and in fact it was at it's in paragraph 39, it stated, additionally, it is unclear whether the factual assertions contained in Pasquan's declaration are disputed. Because Helvetica prevailed below on its claim that refinancing destroys purchase money status, such issues have not been litigated. Nothing in this opinion prevents their litigation on remand. So this was just the factual record that was submitted. Helvetica won below based on a refinancing destroys purchase money protection. This court disagreed, remanded it. The issues that were in Pasquan's declaration were then litigated. We learned, one, it was not a teardown. It was not even close to a complete teardown. The most of the house was not demolished, unlike the declaration stated. And what actually happened was there was this project over a period of years where an existing 4,000-foot house was expanded and additional work was done, such as enclosing a garage, preparing a standalone garage, putting up screen wall and gates, landscaping, purchasing appliances. Those under the definition of the statute would not qualify as purchase money. Purchase money is a loan that is used to satisfy all or part of the purchase price. If I purchase something, I buy something and I have it. It's not purchase money if I've already bought something and then I try and make it better. It just doesn't go against a common sense definition. And we believe here the only purchase money portion of this case is the Hamilton loan in the amount of $600,000, and everything else is not.
You got any problem with adding on the the loan costs, interest paid on that? I mean, doesn't that make sense now in view of the later Chasen case? So it's not only the 600, but it's all of the fees and whatever attributable to that.
If you were to make it into a small percentage based on the $600,000, I don't believe that all of the interest payments on the Helvetica loan are not covered. In fact, I think Helvetica once said they specifically were not protected by the anti-deficiency statutes, and I think that is part of the law of the case. However, to the extent there was going to be an allocation to the original $600,000 as to the interest, I think that is something this court could do. But I believe it mostly just be towards that $600,000.
What were the interest payments that we were addressing in Helvetica 1?
They were the $32,000 interest payments per month on the Helvetica loan.
So that was what was paid monthly after the refinance of the construction of the
Desert Hills Bank loans.
Desert Hills. So
they weren't paid, but yes.
So they were included within the debt, effectively. It was one of those. Is it the case that the loan, they were borrowing for the interest payments?
Correct. The Pasquans took out a loan, and there was interest on the loan, and then they had to make interest payments. It was an interest-only loan, is my recollection offhand. But they did not make the interest payments, so when we eventually got the judgment, it included the interest in there as part of it. Yes.
Yeah, I see, because it wasn't paid. Is there any problem with attributing a pro rata component to that interest, those interest payments?
I think if we're sticking with the rule that the $600,000 purchase money is always purchase money, I think that would be appropriate.
Okay, that would be appropriate.
At a pro rata, not to say we can never recover interest, but
okay.
Yes, I think I think that'd be a logical conclusion from that.
Okay, thank you.
Unless there are any further questions, I appreciate the court's time.
That's good. Thank you. Thank you to you both.
Thank you.
We'll take the matter under advisement and issue a decision in due course. We're going to recess now to allow the next case to come forward, but we're just going to stay here, so go about your business.
Okay. Thank you very much.
Glasses, I flew off.